bringing an arrested person before a magistrate. Duty of officer, it is a fundamental rule of procedure well grounded in the common law that where an arrest is made, the alleged offender is to be taken before a magistrate to be dealt with according to the law. This is not only to be done, but done without delay. Without delay means if you're arrested at 3 a.m, and you demand, hey, I need to see a magistrate. I demand you take me to the magistrate. Hey, I ain't playing with you. I want to see a magistrate right now. If you don't take me to a magistrate right now, this constitutes false arrest and false imprisonment. You do not get to use discretion to hold my body and trespass against I, becoming a wrongdoer under the guise of your alleged authority. You're not the judge, jury, and executioner on the side of the motherfucking road, asshole. And I want to see a magistrate right now. And you just keep repeating that over and over and over and over and over again until you're blue in the motherfucking face. I want to see a magistrate. I demand to see a magistrate right now. I demand to be taken to the nearest magistrate effective immediately because the courts are open 24 hours a day, 7 days a week. Now, the officer will often come back and say, the courts aren't open 24 hours a day, 7 days a week. Oh, really, jackass? How do you suspect you get a warrant at 3 a.m? Yeah, because the courts are open 24 hours a day, 7 fucking days a week. All right? Well, that's for us, not you. Oh, so there's not equal protection of the law. So when you want to engage in nefarious activities and go get fucking unsubstantiated fucking warrants without affidavits and everything else, it's okay for you to wake up a fucking judge at 3 a.m. But when you're here violating my fucking rights, I don't have the right to see the same fucking judge that you can wake up at 3 a.m. for a fucking warrant. Get fucked. That's denial of due process of law, and I'm demanding to see a magistrate right fucking now. All right? Or without unnecessary delay. Otherwise, the arresting party is liable for what? False arrest and false imprisonment. Okay? False imprisonment. That's a denial of due process of law. This is why this is one of my favorites, because time and time again, I've been arrested countless times, many of which is because egos get in the way. People that are trained by their police academies and so forth, who are naturally trained by the lawyers inadvertently. They don't see them. They're off in the back pulling all the strings to the little puppets, the instructors, right? And they don't tell them this information, okay? Because quite frankly, they don't want them to know this information, all right? They're selling them down the river by giving them a little bit of the truth, but not the whole truth. And then to top it all off, they say, you guys do have discretion, by the way. You have discretion of whether or not you want to arrest. Not everything is an arrestable offense. However, we will leave it to you. Basically saying that, you know, if you wish to break the law, and because most people are fucking ignorant, it's well worth it for us, for you to just go ahead and throw them in a cage. However, you want to know who's not going to assume the liability for the dereliction of duty of an officer who's engaged in breach of trust and violating his oath of office? It won't be the fucking lawyer. Nope. The lawyer will come in and say, sure, I told him he could do that. Just like I told him he could jump off a 10-story building, but I wasn't providing legal advice at the time. I was just merely telling him that he can do whatever the fuck he wants. I mean, he can shoot off his left testicle if he fucking wants. It's really his prerogative. Is it advisable? Probably not. But can he do it? Abso-fucking-lutely he can. All right? So they're very crafty at the way that they do things. And it's always so they have plausible deniability. And guess who gets sold down the river? That's right. The man that may or may not have had the purest of intentions of executing his job, which he thought he was doing properly due to the fact that he wasn't instructed correctly about the law. He was only given a little bit of the truth and then told he has this magical thing called discretion. Well, wait a minute. If it's a violation of the law, then there is no fucking discretion. The law is the law. The facts are the facts. It's black and fucking white. There's no discretion there. If I see somebody breaking the law, I'm going to intervene. It's a duty of mine to make sure that the fellow brothers and sisters around me are safe and protected. And if somebody's violating the law, the actual law, meaning I'm witnessing them destroy people's property or push somebody around like a gal or a guy or whatever, I'm going to intervene. I'm going to intervene because they are breaking the law. They are violating another man or woman's rights to live peacefully, sensibly, and pursue their happiness. Okay? So my rights stop where yours begin. All right. So basically, you know, you throw a punch out there and you don't quite touch the nose, but you're close to the nose. I haven't violated anybody's rights yet. I might be in his space a little bit, haven't technically violated his rights. He still has the freedom of movement. I still have the freedom of movement. Nobody's being restrained or held against their will or anything like that. And that's just an analogy I use. I would never do that shit, because if I'm going to go off, I'm just going to go off. I'm not going to go off half-cocked. There's no titty bumping, chest bumping, swelling up like a puffer fish, trying to look like a badass. If I've got a reason to do something, I will explain to you why you're picking up your teeth while you're picking up your fucking teeth, okay? So, and it takes a lot to get me there, by the way. I just don't go off half fucking cocked. It takes a lot. But my point to all of this is, if there's actually a law being violated, then there is a duty that is impressed upon you to intervene, so long as you're not putting your own life at risk, or you make the educated decision of whether or not you're putting your life at risk. For myself, it's a lot like a fireman. They run into fires all the fucking time, and they don't give a shit about their life. You know, it's one of those things. You see a fireman behind you, nobody ever gets nervous seeing the fire truck behind him. Nobody goes, oh, fuck, fire truck's behind us, guys. Oh, no. Because they actually serve and protect the people, right? They actually do good for the community. They're risking their lives, and it's very commendable. It's very admirable, right? Nobody sees a firefighter and goes, oh, fuck, this sucks. If this guy is having a bad day or doesn't like me, I risk the imminent peril of either being euthanized, going to jail, or having false charges brought against me. Nobody thinks that about a fireman, right? You see a cop behind you, a state trooper, a U.S. Marshal, a game warden behind you, and you're going, fuck. Don't look in the mirror. He might think I'm eyeballing him and have to fucking enforce his will upon me, right? So, again, duty of an officer. It is a fundamental rule of procedure, well grounded in the common law, well established, okay? Res judicata, stare decisis, that where an arrest is made, the alleged offender is to be taken before a magistrate to be dealt with according to law. The reason they're doing that is they want to see the compelling evidence. What evidence do we have that we can hold this guy? I mean, what law did he break? What did you see him do? And does it justify putting him in a cage? Yes or no? It may not justify putting somebody in a cage. In fact, there may not be an issue at all. In fact, they may say, hey, cut that guy loose. There's no business. We have no business here, okay? You made a palpable error, okay? And that mistake can be forgiven so long as you take me directly to the magistrate. I'm a forgiving man, you know? It says in the Bible we're supposed to forgive our brothers and sisters for the mistakes they make, you know? And so I look at those things and I realize that people are being denied due process of law every day because they use this new nifty little trick they got. We got 72 hours to form charges against you, and we have 72 hours we can hold you before we have to take you before the magistrate for a bond hearing. Wait a minute. What happened to innocent until proven guilty? What the fuck is this? You're going to cuff me, photograph me, fingerprint me, try and stick your finger up my fucking butthole. You want my left testicle print. You want all this shit, and you're going to stick me in a cage? Absent a fact, absent a crime, absent an affidavit? Horseshit. That constitutes false fucking imprisonment and a false fucking arrest. This is not only to be done, but done without delay. That means expediently, expedited, without delay, no hesitation. Get your fucking ass on the phone and call the judge right now. I don't care what time in the morning it is or what time in the evening. I don't care if it's 4th of July and she just sat down or he just sat down to watch fireworks and eat hot dogs with his family. I don't give a shit. All right? You are hereby ordered and demanded to get a hold of the magistrate, or without unnecessary delay. Otherwise, the arresting party is liable for false imprisonment. In Blackstone Commentary, Volume 4, Chapter 21, page 292, it was stated that a constable may, without warrant, arrest anyone for breach of the peace committed in his view and carry him before a justice of the peace. The officer must bring a person he has arrested directly to the magistrate. It doesn't say 72 hours later. It doesn't say when he fucking feels damn good and ready to do it. Directly, immediately, right fucking now. I don't care if you got to drive me to their fucking house and we got to have a powwow on their back patio. Don't give a shit. Immediately. Otherwise, it's a breach of duty. It's a breach of trust. It's a violation of their oath of office. They are 100% fucking liable for failing to do so. But only if, and I say only if, you demand to see the fucking magistrate. All right? Because if you don't know your rights, guess what? In this country, you don't fucking have any if you don't know them. It is the duty of an officer or other person making an arrest to take the prisoner before a magistrate with reasonable diligence and without unnecessary delay. And the rule is well settled that whether the arrest is made with or without a warrant, an action for false imprisonment may be predicated upon an unreasonable delay in taking the person arrested before a magistrate, regardless of the lawfulness of the arrest in the first instance. Thus, even if the arrest was lawful and legal and supported, a failure to take the person arrested to a magistrate will be regarded as unlawful imprisonment. As the Supreme Court of Minnesota held, even though an arrest be lawful, a detention of the prisoner for an unreasonable time without taking him before a committing magistrate will constitute false imprisonment. So they're not necessarily saying that the arrest was unlawful. They're saying the detention, the detainment, constitutes false imprisonment. An exhaustive decision on the common law rule of the process and procedure for arrest, the Supreme Court of Mississippi in cases of Orrick versus State said, by the common law of England, an arrest without warrant for a felony can be made only for the purpose of bringing the offender before the civil magistrate. This procedure is the due process of the law to be followed in depriving one of his liberty. Thus, a failure or even a delay in following this process is an unlawful restraint or deprivation of liberty and thus a type of false imprisonment. The arresting officer has no authority to take a person to a jail and detain him or her there. His duty is to take the one arrested without delay to a court or magistrate, as said by the Supreme Court of Kansas. The law contemplates that an arrest, either by an officer or a private person, with or without a warrant, is a step in a public prosecution and must be made with a view of taking the person before a magistrate or a judicial tribunal for examination or trial. And an officer even subject himself to liability if there is an unreasonable delay after an arrest in presenting the person for examination or trial. The only reason that can justify having an arrested person in jail or detained by the arresting officer is as a necessary step in bringing him before a magistrate, as so stated by the Supreme Court of Rhode Island. When an officer makes an arrest without warrant, it is his duty to take the person arrested without unnecessary delay before a magistrate or other proper judicial officer having jurisdiction, in order that he may be examined and held or dealt with as the case requires. But to detain the person arrested in custody for any purpose other than that of taking him before a magistrate is illegal, and it's also unlawful. Thus, detainment in a jail for the purposes of booking or fingerprinting or investigating the alleged crime or interrogation of the prisoner is illegal and unlawful. In cases involving the commission of the most severe crimes, as in felonies, the one arresting is still required without an unnecessary delay to bring the prisoner to the nearest magistrate or court as a matter of fundamental law, the basics, the very foundation of law, which is due process of law. From the earliest dawn of the common law, a constable could arrest without a warrant when he had reasonable grounds to suspect that a felony had been committed and he was authorized to detain the suspected party such a reasonable length of time as would enable him to carry the accused before a magistrate, and this is still the law of the land. The court went on to state that the officer making the arrest is liable for false imprisonment if he arrests with the intent of only detaining, or if his unreasonable delay causes a detainment. On page 1092, it stated, "It cannot be questioned that when a person is arrested, either with or without a warrant, it becomes the duty of the officer or individual making the arrest to convey the prisoner in a reasonable time and without unnecessary delay before a magistrate, to be dealt with as the exigency of the case may require. The power to make the arrest does not include the power to unduly detain in custody, but on the contrary is coupled with a correlative duty incumbent on the officer to take the accused before a magistrate as soon as he reasonably can. Authorities cited. If the officer fails to do this, and unreasonably detains the accused in custody, he will be guilty of false imprisonment, no matter how lawful the original arrest may have been, citing 1 Hill Torts, page 213 through 214, section 9. Thus, where a person arrested is taken to a jail or sheriff's office and detained there with no warrant issued before or after the arrest, it is false imprisonment. The one arresting has a duty to immediately seek a magistrate, and that the failure to do so in the 21st century constitutes an unlawful imprisonment or a false imprisonment, makes a case of false imprisonment as a matter of law, is held by all the authorities. In a case involving an indictment for assault and false imprisonment, the Supreme Court of North Carolina held that in the process of a lawful arrest, the one arrested is to be taken immediately to a judge. The question occurs, what is the officer to do with the offender when he or she shall have been arrested without warrant? All the authorities agree that he should be carried as soon as conveniently may be possible before some justice of the peace. Though this case involved an arrest without warrant, the court said it is the duty of the arresting officer upon making an arrest, whether with a warrant or without one, to carry the offender at once before a justice. To take an arrested person to a jail to be detained and fingerprinted is a violation of his rights. It is proof the officer had no intent to bring the accused directly to a judge. In Anderson's treatise on the law of sheriffs, the subject of an officer's duty after arrest was examined with this conclusion. It is the undoubted right on the part of a prisoner on being arrested by a public officer or private citizen, and unquestionably a corresponding duty on the part of the one making the arrest to take the prisoner before a court or a magistrate for a hearing or examination, and this must be done without unnecessary delay. The object of this right and corresponding duty is that the prisoner may be examined, held, or dealt with as the law directs and the facts of the case require. It is highly improper and an invasion of the lawful rights of the prisoner to take him to any other place than to the proper court or magistrate. In deciding the proper duty and actions of an arresting officer after making an arrest, the Supreme Court of Appeals for Virginia stated that the right of the accused to prompt judicial examination does not depend upon their statute law. But even if the circumstances of the arrest were not within the purview of this particular statute, it was the duty of the arresting officer to have taken the defendant within a reasonable time or without unnecessary delay before a judicial officer in order that the latter inquire into the matter and determine whether a warrant should be issued for the detention of the defendant or whether he should be released. And in speaking on the manner of arrest, where lawful at common law, and what are the procedures under the common law when an arrest is made, the Supreme Court of Rhode Island held that, coupled with the authority to arrest, went an imperative obligation on the officer to bring a magistrate without unreasonable delay. Especially was this true where the arrest had been made without a warrant. When an officer makes an arrest without a warrant, it is his duty to take the prisoner arrested without unnecessary delay before a magistrate or other proper judicial officer having jurisdiction. May be examined and held or dealt with as the case requires, but to detain the person arrested in custody for any purpose other than that of taking him before the magistrate is illegal. So that means when they photograph you, take your fingerprints, book you in, all that shit, they're absconding from their duty, which is to take. They're showing wanton disregard, intent, in intentionally booking you in constitutes a false imprisonment, false arrest, because they didn't take you directly to the magistrate. In fact, what they did was they took you in to book you in so they could get paid, because it's a commercial activity. This rule of law requiring an officer or person arresting to bring the party arrested before is the same in all states and cannot be abrogated by statute. The same rule has been upheld in federal courts and is prescribed under Title 18 in the Rules of Criminal Procedure. An officer making an arrest under a warrant issued upon a complaint, or any person making an arrest without a warrant, shall take the arrested person without unnecessary delay before the nearest available federal magistrate, or in the event that a federal magistrate is not reasonably available, before a state or local judicial officer authorized by Title 18 U.S.C. subsection 3041. In a federal case where a man was arrested by 2 FBI agents assisted by 2 local policemen on an outstanding warrant for a bank robbery, the agents placed the man in a vehicle, drove a few blocks, and then parked on the street underneath a street lamp. The officers interviewed the man concerning the crime, and within a few minutes, he confessed to the crime. The Federal Court of Appeals said that the confession was inadmissible and reversed his conviction. As the momentary parking of the police vehicle en route from the place of arrest was a detour from the path toward a prompt presentment before a magistrate, the court stated. The law requires an arresting officer to bring an accused before a magistrate as quickly as possible. Case cited. The rights of the accused were violated as he was not promptly taken before a judicial officer as the law required, but instead was questioned while held in custody. It is said that the police are guilty of oppression and neglect under the color of authority of their duty when they willfully detain a prisoner without arraigning him before a magistrate within a reasonable time. In a case where a person sued for being arrested without warrant and confined in a jail without examination before a court or magistrate, it was found on appeal that such action was unlawful, and the Supreme Court of Illinois, we are of the opinion the arrest of the plaintiff was illegal and the verdict contrary to the law and the evidence. And if the arrest was legal, they did not proceed according to the law and take him before a magistrate for examination, but conveyed him to another county and there imprisoned him in the county jail in a filthy cell, thus invading one of the dearest and most sacred rights of the citizen secured to him by the great charter of our land, Kinder versus Stitt, 409, 1869. The requirements of bringing an arrested person directly to a court or judge is due process of law, and as such, this procedure cannot be abrogated by statute or by anyone. Furthermore, as a trespasser ab initio, it is a familiar rule of the that one who abuses an authority given him by the law becomes a trespasser ab initio, a wrongdoer. That is, he becomes a wrongdoer from the beginning of his actions. Where one fails to take a prisoner he has arrested to a proper judge, or where he causes an unreasonable delay in doing so, the officer becomes a trespasser, a wrongdoer ab initio. The unlawful confinement by an officer makes the entire transaction, including the arrest, unlawful and a trespass. You gotta love sharing this information. I've been interrupted more in this little broadcast than I ever have been before. It's funny. Thus, even in cases where an executive officer had made a lawful arrest, if he fails to bring the arrest to he becomes a trespasser ab initio and Are you done, Facebook, fucking with me, you assholes? An officer who has lawfully arrested a prisoner may be guilty of a false imprisonment if he holds him for an unreasonable length of time without presenting. I just want everybody to know I absolutely have great Wi-Fi and cell phone service, so these interruptions are rather peculiar. Okay, without presenting him for hearing or procuring a proper warrant for his detention. The New York Supreme Court of Appeals stated that the correct exposition of the law in a case where it said that even though the arrest when made was legal and justified, the officer became a trespasser in ab initio and a wrongdoer, so continued to the time of plaintiff's release because of the failure to take him before a magistrate as required. And the Court of Claims of New York, in a case where the officer delayed in the claimant's arraignment, held that if there was an unnecessary delay in arraigning the claimant before a justice of the peace, then the arrest itself became unlawful on the theory that the defendants were trespass acts, and so continued down to the time when the plaintiff was lawfully held under a warrant of commitment, regardless of whether or not the plaintiff was guilty of any crime. Numerous cases cited in Pastor versus Reagan, Supra, it is said that the rule laid down in the Six Carpenters case, 8 Coke 146, that if a man abuses an authority given him by the law, he becomes a trespasser ab initio, has never been questioned. Where one was arrested for being intoxicated and confined in a prison without judicial inquiry, it was held to be a wrongful imprisonment. On this matter, the Supreme Court of Washington stated, nor is a police officer authorized to confine a person indefinitely who he lawfully arrested. It is the duty to take him before some court having jurisdiction of the offense and make a complaint against him. Any undue delay is unlawful and wrongful and renders the officer himself and all persons aiding and abetting doers from the beginning. Thus, when one fails to perform part of his duty and it impinges upon the rights of a citizen, he is said to be a trespasser from the beginning because his whole justification fails, and he stands as if he never had any authority. He never had any authority to act at all. Detainment is not a decision of arresting officer. The basis of the well-established procedure and law of taking a person arrested directly to a judge or a court is to avoid having liberty of the citizen by officers. We believe that fundamental fairness to the accused requires that he should, with reasonable promptness, be taken before a magistrate in order to prevent the application of methods approaching what is commonly called the third degree. Fundamental fairness prohibits the secret inquisition in order to obtain evidence. This is just fucking ridiculous. What's up, Keith? Other reasons for the purpose of this rule requiring that the arrested accused be taken before magistrate as quickly as possible is to make certain that the person arrested is advised by a judicial officer of his constitutional rights. This is not a duty of the officer through the erroneous Miranda warning. The only reason such warning are being used is because police are not doing their duty in bringing them, but instead are unlawfully taking them to a jail to have them booked. The detainment of a person after he is arrested is a judicial question. A judicial officer must decide if there are grounds for holding the person arrested, or whether he must be examined by, or if he is to be bailed and released. To allow the executive department such powers of decision making is the epitome of despotism. In a suit for false imprisonment where several officers arrested the plaintiff on the grounds of committed a felony, the Supreme Court of Massachusetts held the officer had no right to decide to detain the plaintiff to enable them to make a further investigation of the charges against him. The court declared, but having so arrested him, it was the officer's duty to the magistrate who could determine whether or not there to hold him. It was not for the arresting officer to settle that question, authorities cited. The arresting officer is in no sense his guardian and can justify arrest only by bringing the prisoner before the proper court. That either the prisoner may be liberated or that further proceedings may be instituted against him. In a case where one of the accused by another of stealing a watch and subsequently arrested and put in jail for 1 hour and then released, the sheriff was found imprisonment as he failed to take the prisoner arrested before a magistrate. The Supreme Court of Indiana upheld the conviction, stating that the power of detaining a person arrested or restraining him of his liberty is not a matter within the discretion of the officer making the arrest. The court further stated that the sheriff cannot legally person arrested in custody for a longer period of time than is reasonably necessary under all the circumstances of the case without possessing a proper warrant or taking him before a magistrate. If he does, it is false imprisonment. Thus, where a sheriff had arrested and detained them for 5 hours without making any effort to take them before a magistrate, he was guilty of false imprisonment. In this case, the Supreme Court of Idaho said the rule seems to be that an officer arresting a person on criminal process who omits to perform a duty required by, such as taking the prisoner before a court, becomes liable for false imprisonment. The law never allows an officer at his discretion or detain him in a jail after arrest. We have no doubt that the exercise of the power of detention does not rest wholly with the officer making the arrest, and that he should, within a reasonable time, take the prisoner before a circuit criminal or other judicial court. In a case where the arrest is made under a warrant, the officer must take the prisoner without any unnecessary delay before the magistrate issuing it, in order that the party may have a speedy examination if he desires it. And in the case of an arrest, the duty is equally plain, and for the same reason, to take the arrested party before some officer who can take such proof as may be afforded. Executive officers or clerks are not to determine if a person arrested is to be held or released upon bail, or fix the amount of bail, since the power to do so is strictly judicial. In a case where a person was unlawfully arrested for driving an automobile while intoxicated, the arresting officer delivered him to the jailer at 30 p.m. with the instructions that he can be held there until 9 o'clock p.m., at which time he was to be brought before a judicial officer. The Supreme Court of the Appeals of Virginia condemned this act, asserting that the officer usurped the function of a judicial officer, but the actions officer and the jailer in denying the defendant this opportunity to judicial review by confining him in a jail because they concluded that he was not in such condition to be admitted to the bail had the effect of substituting their discretion in the matter for that of the judicial officer. Under the circumstances here, the defendant was clearly entitled to the benefit of the judicial opinion and judgment upon the question for bail. This right was arbitrarily denied him. Executive officers cannot hold a person in order to complete paperwork or make out reports. A man was arrested. Go ahead and pause me, Facebook. Go ahead and fucking scrutinize me here. Without warrant and confined in the county jail without a commitment, the sheriff should not justify the confinement of the man by awaiting the pleasure of a deputy or anyone else to file a complaint. The power of the executive officer over a person's liberty ends with a lawful arrest, and he never has a discretionary power to detain the person without judicial authority. If the plaintiff was being detained for the purpose of arrest, it was the duty of the arresting officer to take him before an examining magistrate as soon as the nature of the circumstance would reasonably permit. The power to arrest does not confer upon the arresting officer the power to detain a prisoner for other purposes. Arresting and releasing without bringing before a judge. While most of the emphasis on this type of false imprisonment deals with the delay in presenting a prisoner to the judge, the real duty and requirement is the actual presenting the prisoner before a judge. Thus, a complete failure to do this is obviously unlawful, and this most often occurs when the officer releases a person he arrested without judicial presentment. An officer who arrests an individual does not have the authority to place such person in a jail or other holding place and then later release him. As we revealed in the case of Harness versus Steele, where the sheriff placed the person arrested in jail for 1 hour and then released him without bringing him before a justice of the peace, he was thus guilty of false imprisonment. It has become the common practice for arrested persons to be taken to jail or a police station to be booked, fingerprinted, photographed, measured, questioned, imprisoned, and then released after a paperwork is completed. This wicked and oppressive procedure is so far removed from what due process of law requires, it is shocking that such measures could be widely accepted as legal. The process of imprisonment and release at the discretion of the executive officer was condemned by the Supreme Court of Illinois in stating, when officers assume the power to imprison without authority of law or without any formal and necessary to be, they become liable for false imprisonment. The liberty of the citizen cannot be so far trifled with that any constable in the land may, of his own volition, commit and hold him in custody until it suits his convenience or pleasure to release him. When a constable or sheriff decides to release the prisoner arrested without taking him before a magistrate, he assumes judicial powers upon himself and is liable. Thus, where a town constable arrested a person who was intoxicated and imprisoned him in lockup until he became sober and then released, taking him before a magistrate, he acted unlawfully and is liable. In this case, the Supreme Court of North Carolina stated, men may not be arrested, imprisoned, and released upon judgment or at the discretion of a constable or anyone else. If the alleged offense be criminal in its character, the officer may arrest and take the offender before a magistrate for trial. The constable arrested and imprisoned not for the sake of keeping until he could be tried before a competent tribunal, but he imprisoned him until he became sober according to his judgment, and then released him. The constable thus constituted himself the judge, jury, and executioner. This is the best description of despotism. When an officer institutes an arrest, he now has undertaken the duty to bring the arrested party to a magistrate. The person can only be released by judicial, not executive authority. The duty of the one making the prisoner before a proper magistrate, that proceeding for the trial of the prisoner may be instituted, and that he may have an opportunity to give bail or otherwise procure his release, is even more impugnative than if a warrant had been issued before arrest. And if the prisoner is for such magistrate, the officer or private person who made the arrest becomes a trespasser ab initio. Arresting a person is a step in a prosecution, and if he is released not according to the law, it is an escape. Such an escape is a departure of a prisoner from custody before he is discharged by due process of law. If pursuant to a warrant, he must be taken to a magistrate before he can be released. 1 Wharton CR period PRC period 195. In deciding if the chief of police acted properly when he put 2 individuals he arrested in jail overnight and releasing them on their depositing bail, the Federal Court of the Appeals said the action of the officer in this case were arbitrary and unjust. The police chief had no right to and then release the prisoners without a hearing before a judge. The court said, in an able opinion, ex parte Harville 267 F period 997, 1003, Judge Connor said, the imprisonment in jail of a citizen without warrant for a hearing or to give bail is a serious matter. The duty in every case is imperative upon the officer to forthwith carry the person arrested before the nearest judicial officer having jurisdiction to hear and determine the legality of such arrest. Ex parte von Hoven, Fed case number 16,825 CJ 491 and 493, the general rule is stated as follows. One making an arrest may be liable in an action for false imprisonment where he fails to take the person arrested before the officer designated in the warrant, or if the arrest is made without warrant to the nearest committing magistrate. If a prisoner accepts his release or is released at his request,